Following the receipt of a copy of judgment delivered by the Federal High Court Abuja ordering two plaintiffs to vote with their temporary voter card, the Chief Press Secretary of INEC Chairman Rotimi Oyekanmi says the Commission is taking immediate steps to appeal against the judgment. Justice Obiora Egwuatu gave the order allowing the use of temporary voter cards while delivering judgment in a suit filed by two Nigerians seeking the use of temporary voter cards in the forthcoming election in the absence of permanent voter cards. Justice Egwuatu said the order was made on the grounds that both plaintiffs were duly registered and captured in INEC's database. Let's talk to a lawyer, Bolanle Olugbani, for more on this development. Mr. Olugbani, it's interesting the judgment we're hearing from the court saying that these plaintiffs haven't fulfilled their legal requirements to register, now have the entitlement to vote. Well, we'll get back to Mr. Olugbani in the course of this bulletin for more on that development. We told you earlier that INEC has now received a copy of the judgment by a federal high court in Abuja ordering two plaintiffs to vote with their temporary voter card. Lawyer Bolanle Olugbani joins us now on TVC News at 10. This judgment is saying that the plaintiffs haven't fulfilled the legal requirement to register and haven't been captured on INEC central database, having their voter identification number. They have the entitlement to vote using their temporary voter card. Mr. Olugbani, this doesn't quite align with INEC's guideline that requires that the voter present a PVC at the polling unit. Is this breaching any provision of the Electoral Act of 2022?
Well, the law is the law. Section 47 of the Electoral Act allows for voter card. There is no distinction between temporary voter's card or permanent voter's card. It simply says voter card. And as such, a guideline is not a law. A guideline is a guide that supports a law. It's not actually the enactment of the National Assembly as is provided for in the Electoral Act. The guideline is beneath the law itself, and as a result of that, the law must be complied with. So
let us explore the practicality of this judgment. I don't know if you voted yourself. INEC says the BVAS is meant to authenticate the genuineness of the PVC. So you present your PVC and then using the facial and biometric capacity of the machine, they can tell whether you are the true owner of the card. But we do not know if the BVAS is pre-installed with all of the information of registered voters, including those who have not collected PVCs.
Well, from the point where, yes, I can't hear you right now.
I can hear you, Mr. Olugbani. I was asking for the practicality of the judgment. If, for instance, the BVAS doesn't capture the registered voters without PVC, how do they vote with their temporary voter cards?
Well, the reality is that from the point where your name is written, you already automatically, under the old system of registration, have a voter identification number. Your voter identification number is the foundation upon which any other form of capturing, whether it's your thumbprint or whether it's your facial recognition, will be an additional form of identification. So once you have a voter identification number under the old manual system or under the BVAS system, you are already captured in the INEC database. And so, having fulfilled that requirement, being registered, captured under the INEC, captured within the INEC database, one has a voter identification number. There should be no obstruction or obstacle to being allowed to exercise one's franchise, that is the ability to vote.
So the judge said that is unable to grant prayer 3, which was to enable every eligible voter with a temporary voter card to be able to vote. According to him, that suit wasn't brought in a representative capacity. Are we looking at the possibility of a change in the old dynamics of voting according to INEC's guideline?
Well, a foundation has been laid. The law itself and courts, that we approach are not Father Christmases. You do not get what you did not pray for. And as such, the suit not being in representative capacity, for instance, somebody from each state of the federation representing the voters of every state, or in addition, a voter from every of the 770-something local governments in Nigeria representing all those in the local government, and a representative suit. If there was if those parties are not in representative capacity, the judge cannot make cannot give a relief that was not asked for, cannot give a judgment that covers the entire populace, even though the court is empowered, but the court has jurisdiction to handle such matters regarding INEC. But because it was brought by two citizens in their own individual capacity and not representative capacity, judgment will not be of general application at this point in time in Nigeria.
INEC says that it's taken immediate steps to appeal the judgment. It means the last has not been heard on this matter. But we have to leave it here.
They may not be able to vote.
Lawyer Bolanle Olugbani, thank you for talking to us.
Thank you. Thank you very much.